While we were discussing section 42 of specific relief act, we saw that a suit for declaration is competent to declare right of a person as to property and to declare the legal factor. The section 42 relates to the declaration, but there is another section which is known as section 39. This section states the circumstances when cancellation of an instrument may be ordered. In its effect, this section is also a declaration. When we seek the cancellation of document, in fact we are seeking the declaration. But there is a distinction between section 42 and 39. Section 39 relates to the declaration of legal character and right as to property, while section 39 deals with the cancellation of an instrument which is void or voidable. If there is an instrument which is void or voidable, and there also a denial of a right on account of that document, then the suit becomes a suit for declaration and cancellation. So there is no open distinction between the two. The only thing which requires is that in the first situation, when we are talking of section 42, it relates to the declaration of rights and also bars the suit when there is another relief available and the person is not going to avail it. So the proviso shall hit. But so far as section 39 is concerned, where the cancellation may be ordered under section 39 under circumstances given therein. Today we are discussing not section 42 but section 39. I'm going to read the same. Any person against whom a written instrument is void or voidable, who has reasonable apprehension that such instrument, if left outstanding, may cause him serious injury, may sue to have it adjudged void or voidable, and the court may, in its discretion, so adjudge it to be delivered up and cancelled. If the instrument has been registered under the Registration Act, the court shall also send a copy of the decree to the officer in whose office the instrument has been so registered, and such officer shall note on the copy of the instrument contained in his book the fact of its cancellation. So as we have seen, section 39 has certain ingredients which are to be fulfilled for the purpose of adjudicating a document as void or voidable. This section deals with two types of instruments. Number one, those which are not valid, meaning thereby those which are void or voidable. So there are certain documents which are void and there are certain documents which are voidable. So how it is to be determined as to document is void or voidable? First of all, we have to see as to document is void or voidable. The voidable documents have been enumerated in the Contract Act. So a document which is void at the option of any person who is interested to deny it is voidable at his option. And a document which is unlawful in its inception is void. So there is a distinction between a void document and a voidable document. Now a question arises. If a voidable document is left unchallenged, if a voidable document is not challenged before the court, and any party on whose option it is voidable accepts the same, then the voidable document need not be challenged. Voidable documents become void because when the option is exercised by the person aggrieved to declare it as void. So this section relates not only to the voidable documents but to the void documents also. So certain documents which are void in their inception may be challenged. But the question is that if a document is void, why should we challenge? Is there a need to challenge it? So the answer to this question is given in section 39 itself. It says that a person has apprehension that such instrument, if left outstanding, may cause serious injury. So now the question involved is that the documents which are causing serious injury are to be cancelled. In other simple words, we can say, if a document is an impediment in the way of exercise of a right, so the impediment is to be removed. Even if the document is void or voidable, it may be an impediment in the way of a right of a person. And when it is an impediment in the way of a right of a person, the person has very much a right to challenge the validity of that document in the court of law. So the court shall adjudge it as void. What does it mean? Adjudge void or voidable. So it is the adjudication which is required for the purpose of determining the voidability and the existence or validity of a document. So for the purpose of determining whether an instrument should be cancelled or not, there are certain ingredients thereof. So when those ingredients are fulfilled, then the court shall adjudge the document as void. The instrument must be in writing. If there is no writing, there can be no instrument. Oral transactions are not instruments. Dialogues are not instruments. Conversation is not instrument. Negotiation is not instrument. The instrument is always in writing. So the writing may be of two types. It may be in a language. The writing may be through visible representation or through signs. When there are signs explicitly showing the existence of a written instrument, when there are visible representations representing certain things to be in writing and are evident of certain facts, those visible representations are also instruments. So when we talk that the instrument should be in writing, it means that there is a visible representation, there are signs, and there is writing in any language. It may be recorded by the hands of a person, or by the typographical way, or in any other mechanical way, or in any other scientific method. It is immaterial how this document was prepared. The only thing which requires that it is a written instrument. If it is a written instrument, then the question will arise as to whether it is void are voidable at the option of any person. If it is voidable at the option of any person, and the person chooses to challenge the validity thereof, he has every right to get it declared as voidable and may abstain from performing whatsoever has been given in the terms and conditions of the agreement. The agreement, which is in writing, also depicts certain terms and conditions. And if those conditions are not binding on a person, on certain accounts, that may be given in the instrument itself or in the contract act, the person is entitled to get it determined as to the terms and conditions are void or voidable. So the basic thing which is to be seen, that a document is a written instrument. Suppose a person himself writes an instrument. After writing, he keeps the same in his pocket and does not use it. Is there any need to get it cancelled? The person against whom he has written this document should get it cancelled. So the answer is given in this section, as I have already read. If the document is left outstanding, may cause him serious injury. The document kept in the pocket is not causing any injury. It shall cause injury when it shall be brought to light, when it shall be used by, when it is supposed that the person is going to use it to the detriment of the person who is going to have the right to get it challenged. So in this situation, where the document is written but is not causing any serious injury, then the court shall not get it cancelled. It shall only be got cancelled in the circumstances when the court feels that it will cause a serious injury to the person. Now, what is a serious injury and what is not a serious injury is a question which is to be determined by the court. And generally, when there is a threat or invasion on the right of a person as to immovable property, the law presumes that it is going to cause a serious injury. If a person is owner of the property, and owner of the property has every right to enjoy the possession of the property, but a man having an instrument prepared against him comes in the field and gives a threat to him that on account of this document he is going to dispossess him, meaning thereby that he has got the threat of a serious injury which will be caused on account of this document, he may come to the court to get it cancelled and may sue the court to have it adjudged as void. But what is the need to get a document cancelled? Why it should be cancelled? If you are owner of a property, you are in possession of the property, you are enjoying the ownership and possession of the property, but another person has got an instrument against your rights regarding the same property which is owned by you and possessed by you, then should we file a suit for cancellation of document? Now it is to be seen by the court that the document in possession of a person, what harm it is causing to the person who is owner in possession of the property. If this instrument is a source of threat and invasion on his right and intended to cause a serious injury, then the document is to be cancelled. But if a document is not causing any injury, even if it is against the interest of a person, the court shall not adjudge it so. So the document is adjudged as a void or voidable document if there are circumstances which enable the court to come to this conclusion that it will cause a serious injury. This question of serious injury is of serious nature. How the court determines that this document is causing serious injury and how this document shall not cause any injury, how it shall be a serious injury. So this is the question which is to be determined by the court. So on the principle that the court should not go beyond the pleadings, the pleading should explain as to how this instrument is seriously injuring the right of a person. So it should be in the plaint itself that this document, this instrument which is in writing is going to threat him, and the injury which is expected to be caused by the use of this document is very serious. The seriousness of injury is dependent on two things. Number one, on the question of the nature of a right of a person which is going to be infringed, and on the consequences which may cause on account of use of this document. The seriousness of injury is very much material in this case. So an instrument, if it is required to be cancelled, the seriousness of injury is very much material. The serious injury does not mean the injuries which are given in the Pakistan Penal Code, but it means the injury to the rights of a person. What are the rights of a person in relation to the property about which this document has been created? So the right of a person are the determinative factor of the seriousness of injury. If this document is left outstanding, what injury it shall cause? Suppose there exists a document and this instrument is in writing. It is in the hand of a person. Why should you go to the court to get it cancelled? For the purpose of determining the criteria for the cancellation of this document is again the serious injury. Injury means to injure the rights of a person, either right of a person or right as to property. If it is injuring the right of the property, then it may be a serious. And if it is injuring the person of a property, of a person, it shall also be serious. So the seriousness depends upon the circumstances of each case. There are certain cases when the injury is not serious. Suppose a person prepares an instrument and writes therein that I paid A rupees 100. He shall pay these 100 to me tomorrow. Should this document be cancelled? It should not be cancelled, because when tomorrow comes, the cause of action shall arise in favor of that person who is possessing the document. He should go to the court for the recovery of 100 rupees, and the person against whom the document has been prepared should not go to the court. He does not require to get it cancelled. There is no seriousness in the injury. And even there is no question of any injury there. He wrote a document of 100 rupees and kept in his pocket for tomorrow, and tomorrow he is not using the same, then you should not go to the court to get it cancelled. So this document should only be cancelled in those circumstances when it is causing injury to you. It is not causing any injury to you. We usually see that our friends file suits for cancellation of certain receipts, file document for cancellation of check, for cancellation of furrow note. So they must write in the pleadings, in the plaint, that if this document is left outstanding, it shall cause a serious injury. Prima facie, it is not causing serious injury. But if he feels and if he has a threat or invasion which may be amounting to a serious injury, then he must explain it in the plaint. Normally it is not a serious injury, but it becomes serious when it becomes a threat on your right. Suppose a man writes a furrow note in his favor and makes an application before the police station to extort the money from you on the basis of that document, then you have a threat to your personality, you have a threat to your reputation, you have a threat of being defamed, you have a threat of being arrested by the police. Then this document, who is ordinarily not a serious injury to you, may become a document which is causing serious injury. So this is the reason why the law requires that if you are going to get a document cancelled, you must plead that if it is left outstanding, it shall cause serious injury. So that injury is to be explained. And the court will see as to the injury which you are alleging is serious or not. If the injury is serious, then the court will take the cognizance. The court will try. The court will proceed further. But if it is not causing any serious injury, the court shall not proceed. So it is necessary that there should be a written instrument, number one. Number two, it is going to cause a serious injury. And number three, in view of the circumstances of the case, the court considers it reasonable and proper to get it adjudged as void or voidable. Now the third portion is relating to the discretion of the court. You will see that in all relevant provisions of specific defects, the relief is always discretionary with the court. Why it is discretionary with the court? Because these courts are courts of equity, and the court requires that the document which is going to be challenged is to be set aside only in the circumstances when it is equitable to do so. But if it is not equitable, then the court shall not judge it. So, in order to appreciate it, I am going to give a citation. (203) YLR, page 1570. Cancellation of document. Provision of section 39 specific defect enables any person apprehending that a written instrument which is void or voidable, and if left outstanding may cause him serious injury, to approach a competent court for getting the document as judged. इसके साथ एक और authority 204 2004 YLR page 577. Suit for cancellation of a document. Plaintiff must allege that if the impugned instrument was allowed to exist, the same would cause him injury. Under Section 39 of Specific Act, suit for cancellation of instrument would be through a declaration for cancellation of the instrument, declaring the same to be void or voidable. The most important thing which has been enumerated in this authoritative pronouncement is that there shall be a declaration. We were drawing a distinction between declaration and cancellation. But this authority says that the cancellation is also in terms a declaration. So when you are seeking the declaration that the document is void or voidable and it should be adjudged as void, it is a suit for cancellation. But when you are challenging a document on the basis of your right and the other person is going to deny your right and the legal character, so you are to getting your legal character declared and right as to the property is also to be declared, then that is a suit for declaration. But in its effect, suit for cancellation is also a suit for declaration. Because the court shall adjudge it as void. The court shall adjudge it as voidable. So when the court is going to adjudge it as a void, the court shall be determining the serious injury which could be caused to a person. So under this authority, it is also a suit for declaration. So far as the second part is concerned, we have seen, and the court may in its discretion so adjudge it to be delivered up and cancelled. So this is very important part. It is in fact an implementation of this word, that it is going to be implemented. Now, when the court comes to this conclusion that the document is void, then the court, after adjudging it, will not stop, but the court shall deliver it up and get it cancelled. If it is in the custody of the defendant, the court will ask him to produce it. And when it is produced before the document court, it shall be delivered up and then the court shall cancel it. So in other words, we can say that the cancellation of an instrument is necessary in the circumstances when it is a threat and invasion of the right of a person and the person is under the threat that it will be causing a serious injury if it is left outstanding. So in these circumstances, a suit for cancellation is in its effect a removal of cloud on the rights. If a man has a cloud on his rights on account of an instrument, the court shall adjudge it, deliver up, cancel, and then the cloud shall be removed and the right shall be as clear as the daylight, and the person shall be entitled to use his right as provided by the statute or by the constitution or by the custom and usages having the force of law. I think it is sufficient for today. Thank you.